Once everyone attending the deposition in person or who are attending remotely, it is confirmed that they are properly using their USB boom mics, like you see here, or lapel mics connected to the witness and to all counsel physically attending, and the videographer or digital court reporter is satisfied that everyone's mic meets the high standards required for Otter to generate a successful real-time transcript, then we go on the record, and the screen that the videographer or digital court reporter sees is exactly what you see here.
We are on the record. This is the digital video deposition of Dr. Michael Riley, testifying in the matter of Raylene Stokes versus County of Orange et al. In the Superior Court of the State of California, County of Orange.
There is virtually no punctuation during real time, but Otter will eventually work on that. As soon as there is a recess, for instance a 2-hour of taking down by video or audio, Otter presents for review, in a matter of a few minutes, a synchronized transcript with punctuation that is surprisingly accurate. There is also no question and answer in the left margin or speaker IDs for colloquy. Otter will undoubtedly make it happen at some point. As they say in the software business world, just a matter of interfacing the toaster to the moon.
Case number 30-2010-003-51398. This deposition is being held at 402 North Nevada Street, Oceanside, California. Today is Monday, October 29th, 2012. The time is now 10:09 a.m. My name is Greg Eisman, Legal Video Specialist with Jordan Media Incorporated, 1228 Madison Avenue in San Diego, California. The certified shorthand reporter today is Maggie Smith, in association with Crom Court Reporting, San Diego, California. All counsel will now state their appearances for the record.
Sean McMillan appearing for plaintiffs.
Pat Desmond appearing for the County of Orange, the deponent Dr. Riley, and the other social workers that have been sued in this lawsuit.
By the way, this is being published because this video was found on YouTube, so all privacy matters are non-applicable.
Will the reporter please swear the witness?
If you would, Doctor, please raise your right hand to be administered the oath. Do solemnly state under penalty of perjury, the testimony you give in this matter shall be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Mr. Riley, can you please state and spell your full name, including your middle name, for us?
Sure. Michael Levon, L-A, capital V-O-N, Riley, R-I-L-E-Y.
Okay. Mr. Riley, what position do you currently hold with the County of Orange?
I am the Director of Social Services Agency of Orange County.
And as Director of the entire agency, you oversee all departments, correct?
Yes, I do all 4 departments and approximately 4,000 employees.
Okay, I'm going to show you what we'll mark as exhibit number 133 to your deposition.
Whether you are recording a video deposition, an audio deposition, recording a congressional hearing on Capitol Hill in Washington, D.C., a courtroom trial, an arbitration, a conference, the videographer and the digital court reporter must use the requisite hardware. We insist on it. It is much to your advantage.
Have you had a moment to review that exhibit number 133?
Yes, I have.
It says in the upper right-hand corner that as of July 10th, 2012, that was a current organizational chart, correct?
Yes.
Is that still current?
There have been some changes since that time.
Okay, can you do me a favor, and I will hand you one of my pens, actually my only pen,
Okay.
and ask you if you would to go ahead and interlineate the changes?
Sure.
The window below left is where the videographer, digital court reporter, enters data such as a specific timestamp correlating to the entry of an objection by a lawyer with their initials, spellings from exhibits, and other pertinent information to ensure a correct transcript for the benefit of our editing staff.
There's just been one change, and Nancy Davis in the CalWorks program has retired.
Okay. And she was
She
replaced.
was deputy director for our CalWorks program under Nathan Nishimoto.
Okay. And she has been replaced, correct?
She has not been replaced.
So it's an
It's
open.
vacant right now. They're interviewing probably as we speak.
Just so that I'm clear, and I'll give this back to you. I have a copy for myself, thanks. Just so that I'm clear as to the organization of the agency, it looks like there are 4 basic departments, correct?
Yes,
And one of those departments is Children and Family Services, correct?
that's correct.
And the division director is Gary Taylor?
That's right.
Okay. If you could, I was looking at one of the documents you brought with you here today, and it's titled County of Orange Social Services Agency Program Mandates and Best Practices. I want to make sure I read this correctly. But am I correct that the funding for your programs, 13% of it is devoted to children and family services?
You mean at SSA total budget?
Yes.
Yes.
And approximately 90% of that budget comes from federal and state funding, correct?
That's correct.
How much is that?
It's vague as to time.
Well, how much was it this year?
I'm not certain as far as, because there's several funding sources that flow into to our CFS budget. There is Child Welfare Services budget. There is the foster care budget, which primarily covers which is under Title IV-E, which covers actually group home placement and foster care placement, which that money flows through us out to the providers. The Child Welfare Services program is the one that pays for our overhead for our social workers. And that's usually somewhere around 80, 85 million, somewhere around in there, roughly. I'm not certain offhand. And then we also have monies coming in for adoption services program, which is different, and our AB 12, which is just passed this year, which is for emancipated youth to carry them through the age of 21. So there's several funding sources that flow into CFS.
Let's start with the Social Services Agency total budget for 2012. What was that total budget?
The total budget for operating budget is about $875 million.
Is there some other kind of budget besides the operating budget?
Yes, our total budget is about $2.2 billion. That includes public assistance payments for Medi-Cal and CalFresh.
Okay. And just so that I'm clear, County of Orange Social Services Agency total budget for 2012 was $2.2 billion, correct?
About that.
And of that $2.2 billion, approximately 13% of that went to Children and Family Services, correct?
Actually, 13% would come from the operating budget, which is not the total, because that 2.1 billion, that 2.2 billion, that's on top of the operating budget, and that primarily flows through our public assistance programs. Some of that would be foster care, because some of that is supporting foster parents and relative caregivers, but I don't have the exact breakout for that.
So am I correct that in this program mandates and best practices document that you produced here today for 2012, when you're talking about the funding being 13% of the total funding for County of Orange Social Services Agency, are we talking about it being 13% of the operating budget or 13% of the total budget?
13% of the operating budget.
Okay. Can you show me where on this document it says that?
Relax Foundation.
It doesn't say that here.
Okay. That is a document you produced here with you for your deposition today, correct? That's a yes?
Yes.
Did you review that document before you came to give your deposition here today?
Yes, I did.
Did you participate in any way in preparing that document?
Not in preparing the document, no, I didn't. I reviewed it, but I didn't prepare it.
You reviewed it for accuracy before it was finalized, correct?
Yes, I did.
Okay, and you found it to be accurate?
Yes, I did. However, I did not see that 13% as the total budget. I was just looking at it as operating budget.
And another thing you'd said a little earlier is that the total budget, that $2.2 billion number, was on top of the $875 million operating budget. Did you mean that it's in addition to, so we aggregate the two numbers?
It's, you aggregate the two numbers, so you would separate out the 878 million from that $2.2 billion, subtract that from that. That's all inclusive, total 2.2 billion, including the operating budget.
Okay. Okay, so if we pull out the 875 million from the 2.2 billion, whatever's left would be that portion of the total budget that is not devoted to children and family services.
That's correct.
Okay. So am I correct that roughly 40% of your total budget goes to children and family services?
That misstates the evidence.
Well, what's
No.
875, or, yeah, 2.2 billion divided by 875 million.
That's the total operating budget for SSA, not for children and family services, the 875 million
Okay, the 875 million that
is the total SSA operating budget,
Okay.
which covers our overhead and facilities and maintenance and day-to-day expenses for the most part.
So where does the other 1.4 billion go?
The other goes to we are a flow-through, it goes to our citizens for Medi-Cal, CalFresh, in-home supportive services, refugee services.
So that would be the, if I were to number on Exhibit 133, in fact, let's just go ahead and do that. If you can number 1 through 4, the different divisions.
Okay. Number 1 is Administrative Division. Number 2 is Adult Services and Assistance Programs. That's where we have, again, most of our Medi-Cal programs and CalFresh programs. CalFresh, by the way, is a new name for
Yeah,
food
for the
stamps.
food stamps, I saw that.
California, yeah.
Got to do some rebranding.
Right. And then Division 3 is Children and Family Services, and Division 4 is Family Self-Sufficiency, which houses CalWorks and Welfare to Work programs.
Now, administrative services,
Yes,
that's a basic overhead function, right? That's
that's
essentially
correct.
that's essentially what you have in place to keep all the programs
Correct.
managed and running.
Right.
Okay. One thing you have to do is try to wait for me to finish the question because
I'm
she's trying to
sorry.
write down everything you say. And then adult services, that's a separate program where you're essentially, or the county is essentially providing services to adults who need help, right?
Yes.
And the administrative services division, some of those people actually provide the logistical support and infrastructure to manage that program, correct?
Yes.
And it's the same with regard to CalWorks Family Self-Sufficiency.
Yes.
So the administrative services provide the infrastructure and logistical support to operate the Family Self-Sufficiency division.
Yes.
And it's also the same with regard to children and family services, correct?
Yes.
That is that the administrative services division provides logistical support and infrastructure to operate the children and family services unit.
Yes.
How does the administrative services division divide, or rather derive, its operating budget?
It derives its operating budget for what we call cost applies. For example, for the services that they may, an HR staff person who's, say, working with adult assistance programs, who's working on some personnel issue, that cost is cost applied to the adult services program, which has a completely different funding source. So therefore, any services or support they provide to these other three divisions is cost applied to these other three divisions' budget.
Okay, and by they you mean the administrative services staff, right?
Yes.
So to the extent that the administrative services division provides either logistical support, staff, or infrastructure support to one of these other divisions, there will be a charge somewhere against that division.
Right, with the exception perhaps of the our IT, because we have with our IT, our information technology division, or section I should say, oftentimes we'll get a separate funding stream for them as well to support all of our networks,
Okay,
which are cloud networks.
okay. And is that separate funding source also included in your total budget, which was for this year 2.2 billion?
Yes, that's included in all of that.
Okay. Now, if we focus just for a moment on children and family services, does it also have its own internal infrastructure, or does it use the infrastructure provided by administrative services?
It uses, for clarification purposes, we are one department. SSA is one department. These are divisions of that department. So the primary infrastructure for all of our divisions is provided by the Administration Services Division.
Okay. And then for budgeting purposes, the Administrative Service Division will keep track of which department is using which resources, and then there will be like a line item charge in that department's internal budget.
Correct.
Okay. Does each department have its own employees, or does Administrative Services take care of all that in terms of infrastructure?
Each department has its own employees. I don't have the exact, I used to know the exact number of each division, but with budget cuts kind of lost track. But roughly, our adult services assistance programs is our biggest division, and they have roughly around 1,300 staff.
Can you do me a favor and write down just under, or next to it there somewhere, 1,300
Around
staff?
1,300. And then Children and Family Services is probably around 1,000 or 1,100, somewhere around there. And then actually our smallest division is admin, but then the CalWorks division is probably around 800 or so, roughly.
Okay. And the admin has how many?
Admin,
Just a rough estimate, it's fine.
okay, probably around 700 or 800, somewhere around there. Somewhere in there, to be exact. I didn't.
Sure, no, I understand. Now, the adult services and assistance programs, which their funding also comes from state and federal funding, correct?
Yes, predominantly state and federal funding. Probably only about 8% of that division's funding is net county cost.
Okay. Is that also the same for children and family services? Most of that is from federal and state funding?
The majority is, yes, it is, but the net county for Children and Family Services is more than 8%. It ranges anywhere between 15 to 30%, depending on the service and program provided.
Okay. With regard, and let's just focus for a moment specifically on well, let me ask you this first. Internally to Children and Family Services, I see there's 4 boxes under that division.
Yes.
Can you briefly describe for me what intervention and prevention services does?
Intervention and prevention services is our front-end programs. They, for the most part, do the emergency response, child abuse registry, and they provide all the sort of the family, what we call our voluntary family services program. These are families that are served outside of the dependency system that we refer to. Also, they oversee our differential response, which are families we defer out so that we don't have to bring them into the system. Also, it's over our, we call our Family Resource Centers Network, which is our FACT program. So if you think about prevention and early intervention, that's primarily where all of that happens.
Okay, so emergency response workers, they would be under intervention and prevention services.
That's where they are.
Okay, what about the investigators that come later? What division are they under?
The investigators, for the most part, come under what we call our Family Assessment and Shelter Services program. And that they come, that's our dependency investigation team, and they are attached, well, not attached, but they're in the same umbrella as our Orangewood Children and Families Shelter.
Okay, can I get my pen just for a second? Sorry. So Orangewood, the funding for Orangewood also would come under Family Assessment and Shelter Services? Okay. Do you know off the top of your head, just an estimate, what the annual funding for Orangewood Children's Home is?
And it's approximately $20 million.
And just for foundational purposes, what is Orangewood Children's Home?
Orangewood Children and Families Service Family Center is our emergency shelter for children who are removed into protective custody and where law enforcement bring kids that they find in harm's way.
In harm's way, what do you mean by harm's way?
When they do a drug raid, for example, and there are kids in the home, or when they are involved with domestic violence and there are kids there, and they will oftentimes they call us and we meet them on site.
And then on site, the would that be an ER worker, emergency response
Emergency
worker?
response worker.
And then oftentimes on site, the emergency response worker will make an assessment of the safety of the child?
Yes, we'll work in collaboration with law enforcement.
Okay. And then oftentimes, there on the spot, the child will be removed from the home.
Not necessarily, depends if the perpetrator is removed.
What about when you don't know who the perpetrator was?
When we don't know who the perpetrator is, then that's when we do a more thorough assessment
Before removing the child?
before removing the child.
Now, hospital holds also treated from a legal perspective as a removal, correct?
From a legal perspective, yes.
And you do the same assessment there if you don't know who the perpetrator is or you can't figure out who the perpetrator was, you do a more thorough investigation before you remove the child?
Yes, we do. We do that, and a lot has to do with the age of the child.
Okay. Hold on one second. We'll get into that. What I'm really looking for right now is it's a more pointed question. You do the same assessment with regard to a hospital hold. If you know who the perpetrator is or you can't figure out, scratch that, let me start over. You do the same assessment with regard to a hospital hold. If you don't know who the perpetrator is, or you can't figure out who the perpetrator was, you do a more thorough investigation before you remove the child, correct?
It's been asked and answered.
I can clarify in regards to using the structured decision-making model. As far as if you want to say same, I would say consistent rather than same.
Okay, we'll get into the SDMs too. Let me get an answer to this question. With regard to a hospital hold, you treat that similarly as you would a removal from a home. If you don't know who the perpetrator is, or you can't figure out who the perpetrator was, you do a more thorough investigation before you remove the child, correct?
Been asked and answered. You can answer it again.
That may be, again, it depends on the circumstances. Each circumstance is different. A hospital holds somewhat different circumstances than investigating what's happening in the home with law enforcement. right there, and depending on what circumstances in that environment.
Okay, let me go back to the original question. Maybe you've lost context, and I'll read the whole line of questioning. It's really a
Okay.
yes or no question.
Okay.
Okay. Goes back to the question relative to what you meant by in harm's way. And my question was, in harm's way, what do you mean by in harm's way? Answer, when they do a drug raid, for example, and there are kids in the home, or when they're involved with domestic violence, and there are kids there, and they will oftentimes, they call us, and we meet them on site. Question. And then on site, would that be an ER worker or emergency response worker? Emergency response worker. Question. And then oftentimes on site, the emergency response worker will make an assessment of the safety of the child. Answer. Yes. We'll work in collaboration with law enforcement. Question. Okay. And then oftentimes, there, on the spot, the child will be removed from the home. Answer, not necessarily. It depends if the perpetrator is removed. Question, what about when you don't know who the perpetrator was? Answer, when we don't know who the perpetrator is, that's when we do a more thorough assessment. Before removing the child? Answer, before removing the child. Now, a hospital hold is also treated from a legal perspective. This is my question. It's from a legal perspective as a removal, correct?
Yes.
Asked and answered.
Okay, the answer is yes. And you do a similar assessment there. If you don't know who the perpetrator is, or you can't figure out who the perpetrator was, you do a more thorough investigation before you remove the child, correct?
It's been asked and answered.
For clarification purposes,
I'll clarify it once you answer the question.
No. If he can't answer it yes or no, he can answer it the way he's going to answer it.
Can you tell me right now, can you answer that question, yes or no?
no.
Okay. So a hospital hold then, correct me if I'm wrong, is treated differently from an in-home removal?
Yes.
Okay. Is that in all circumstances?
It's overbroad.
Not all circumstances, no. Each case is different and handled differently.
Okay. Under what circumstances would a hospital hold, the placement of a hospital hold, be appropriate without conducting a further investigation?
It's overbroad.
When we do have, typically when we have a hospital hold, it's important to keep this in context that the hospital calls us because they feel as though there is potential, there's explanation that has occurred. There has been no explanation for the injury of the infant or child, whatever the case may be. As a result, they call us, and when it is a child under the age of 3, and there is no explanation as to how the child was harmed, we do detain the child.
Okay. And that's a matter of practice.
That's a matter of practice when it's called for.
Okay. And who decides whether or not there is an explanation for how the child was injured? Who makes that decision?
We consult with all the physicians involved, medical staff, if we can. At least we will discuss it with medical staff that's available, but really with our child abuse expert, and we will make a determination. From there, the ER worker, in consultation with his or her supervisor, they make that determination. Also in consult
So
with
it's
law
the
enforcement.
emergency response worker?
That's correct.
Okay. And you said earlier that before that decision's made, they'll conduct some kind of investigation?
They will consult with and interview medical staff.
So they will conduct some kind of investigation?
Yes.
Okay. And you also said that as part of that investigation, they would speak with all the treating physicians?
They will speak with the treating physicians that they have access to.
And in the best world, they would speak with all treating physicians.
In the best cases, in the best of all worlds, yes.
And what happens if there on the spot there's a conflict between the treating physicians as to the cause of the child's injuries?
Vague and ambiguous, and it's overbroad.
What we rely on is the advice from our child abuse experts.
So if your child abuse expert is saying, yeah, this was abuse, but other treating physicians are saying, no, this is not abuse, you'll defer to the child abuse expert.
Yes, we will.
Okay. Even in areas where the child abuse expert has no acknowledged expertise in the particular area where the child's injured.
It lacks foundation.
That's not for us to determine. We don't know exactly who has the most knowledge in any particular area. We just know that our child abuse expert, who is a board certified child abuse expert, which there are very few of them here in the state of California.
There's
that's who
actually
we rely
very
on.
few of
you're,
them.
You're cutting him off.
No, it's
Mr.
not.
McMillan.
It's a narrative response objection. And
No. Let him finish his response. You can't cut him off.
yeah, I can.
No, you can't.
When it's a narrative response, it's improper.
No,
I can cut him off. You know that would happen in court too. I would object, narrative response, that would be the end
you
of
can't cut him off, and we're not going to do that.
it. All right, you can go ahead and continue your narrative response unless you're done.
There are very few board certified child abuse experts in California.
Okay, and the reason there are very few board certified child abuse experts in California is because only in 2011 did they start becoming board certified, correct?
I don't know the exact date, but I know it's been
Right.
very recent.
Right. And in 2009 there was no such thing as a board certified child abuse expert, correct?
It's my understanding.
Okay. And in fact, in 2010 there was no such thing as a child abuse or a board certified child abuse expert.
Again, that's my understanding. I don't know.
Okay. So am I correct then that in 2009, we didn't have board certified child abuse experts, so you deferred, and by you I mean the agency, Orange County Social Services Agency, would defer to non-board certified so-called child abuse experts, correct?
It's argumentative.
We would respond to what we would consider experts, even though they may not have been board certified.
Okay. And you would defer to that expert's, so-called expert's opinion over the opinion, for example, of a truly board certified neurosurgeon, correct?
It's argumentative. And it's vague and ambiguous.
It would depend on the circumstances.
Now, currently, you are the head of Orange County Social Services Agency, correct?
That's correct.
You are the highest ranking member of the organization,
Yes.
and you have the authority to set policy for the entire department, correct?
Yes.
And that includes policies and practices for Children and Family Services Division, correct?
Yes.
And before you became the head of the entire agency, you were the head of the Children and Family Services Division.
Before I was the director of Social Services Agency, I was the chief deputy director of Social Services Agency.
Okay, and then at some point before that, you actually were the head of the Children and Family Services Division.
That's correct.
And when was that?
That was from 1997 to 2007.
Okay. That would have been under Larry Lehman,
Yes.
okay. And then later under Ingrid Harita.
Yes.
And the Social Services, Children and Family Services Division, that's the only division of the agency that has the ability to remove children from the care of their parents,
That's correct.
and in fact, the Children and Family Services unit does that frequently.
It's vague and ambiguous.
They do that when it's necessary, yes. I don't know what frequently would be.
Okay, you don't understand the word frequently?
I understand frequently, but it's a matter of depending on the number of allegations we have and the investigations we have. We do it on a daily basis, if that's what you're asking.
Yes, you remove children from the care of their parents on a daily basis.
Yes, we do.
Okay. And in most of those instances of removal, your social workers do not obtain a warrant prior to removing the child, correct?
In most cases, that's correct.
Okay. Just as an estimate, from 2005 to 2009, is it correct that your agency removed about 8,500 children from their homes?
No, that sounds high. From 2005 to 2011, that sounds high. I can tell you roughly, each year we have removed approximately 1,100 to maybe 1,800 kids,
And that's year over year?
and that's year over year. And that's a rough estimate.
Sure. And how many of those instances, again, just a rough estimate, if you know, did your workers obtain warrants prior to removing the child?
I'm not certain, but it would be probably a small percentage of that,
Less than 1%?
more than that. I'm not certain. I can't even answer that because I have no idea, to be honest with you.
Does your agency keep that statistic, how many warrants they've obtained?
We try to keep that statistic, but in accordance with the network that we use, Child Welfare Services Case Management System, there's really no place to collect that data.
Okay. So how do you try to keep that statistic?
We try to keep that statistic manually, which would be difficult to do, to collect that data quantitatively in a scientific manner, if you will, a consistent manner.
Okay. When did you start attempting to collect that data manually?
Probably fairly recent, within maybe the last 2 years or so, maybe. And again, that's a rough estimate.
Who is it that maintains that data?
That would depend on where the child was removed, because all removals aren't necessarily first time with the parent. It could be kids that are already placed, that's say in a group home or something. So it could depends on the section within that division.
Well, actually, children that are already placed in foster care or in a group home, your agency is not required to obtain a warrant to remove
That's
those
true.
children.
That's true for them. That's correct.
Okay. So let's just focus on those circumstances where the agency may be required to get a warrant. And that would be where we're removing a child from its family.
And that's, I guess that's what I was answering. That's where it gets complicated, because we don't, if you will, pull out that data. We don't data mine it that finely, because, again, the network that we use doesn't allow us to do that. When we remove a child, it doesn't discern whether or not it comes from a group home, foster home, or the first time the ER worker has made contact with that family. They look at it aggregate, because the state keeps that information as a removal.
Okay. And isn't it correct, Mr. Riley, that until 2010, in fact, your agency provided no training to its social workers regarding the procedures by which they would obtain a protective custody warrant or removal warrant if in fact they wanted to?
That's not my understanding. There was training.
When?
I don't have the dates. I do know that there's training provided through Public Child Welfare Training Academy, but I don't have the dates as to when. And I do know that in one of the categories it focuses on, of course, ethics, law enforcement, and dealing with the constitutional rights of parents and families.
That was the 2012 mandatory civil rights training, correct?
They had civil rights training before that. Now, whether or not it was specific to warrants training, I cannot answer that, but they've had ongoing civil rights training before that.
Now, this civil rights training that you're talking about, that's training that your supervisors would have gone to, right?
Supervisors go to that, but they also, if you will, provide that information to their individual units.
Okay. And in fact, the 2012 January, February mandatory civil rights training, avoiding, what is that called? Avoiding civil rights liability, I think is what the title of the course was. That's something that all of your workers down to the secretarial level were required to go to, correct?
For the most part, yes.
Okay. And that was the first time that you'd had that specific type of training that was offered to all of the children and family services workers, correct?
That's correct.
Why was that?
We started doing that because it became more apparent that we needed to be more, or our staff needed to be more astute and more aware of what's happening as far as litigation is concerned.
So am I correct then that you did the training not because you were concerned necessarily about the rights of the people that were impacted by your agency, but instead because of concerns over litigation?
We're always concerned about the rights of our families, and we feel as though we've always maintained that concern. What we wanted to do was formalize that training to make sure that everyone was given the same consistent message.
Okay. And that consistent message was what?
It's overbroad.
The consistent message for the most part, which has been the message actually long before 2012, is that it's a practice that we put in place, that I actually put in place in regards to primarily what we want to look at is removal of a child only when it is to be or considered exigent circumstances, or the language that my workers and staff use is imminent danger.
Okay. What's imminent danger?
Imminent danger means that harm can befall the child at any moment, any time, particularly if they're left in that specific environment.
Any kind of harm?
Any kind of harm. It can be physical harm, it could be severe neglect where the child could harm his or herself.
Just so that I make sure I have your understanding of the law clear, you're saying that an exigent circumstance is presented any time that a child could suffer any kind of harm if left in the care of their caregiver.
Yes.
Okay. When did you acquire that understanding?
That has been the understanding for the last several years.
Since at least, what, 2005?
Probably before 2005. But certainly
2002
since,
maybe?
I would say about 2002.
Okay. And that includes emotional harm?
That, again, it depends on the circumstances.
Okay.
Each case is evaluated on its own merit.
So it's your testimony here today that a child could, in fact, be removed from the custody of his or her parents without a warrant if they were suffering emotional harm?
That misstates his testimony.
No, no.
Okay, explain, because I misunderstood.
I'm talking primarily about physical abuse.
Okay.
I'm talking primarily about severe neglect where the child is left, where there's a failure to protect environment, and more specifically for children under the age of 3.
Okay. So, again, just so that I'm clear, it's your understanding that for children under the age of 3, if there is a potential they may be physically harmed, it would be appropriate for your workers to remove the child from the care of the caregiver without a warrant.
Yes, and it'd be more than a potential, it'd be a high probability.
Now, does it have to be... Well, let me ask this. At the time of the removal, Does there have to be any evidence to suggest that it was the caregiver that harmed the child as opposed to somebody else?
At the time when we're doing any kind of assessment, risk assessment, evaluation, investigation with the child that cannot speak, we don't have any idea who the perpetrator may be. That's what complicates those cases.
Well, that doesn't really answer my question, though. At the time of the removal, does there have to be any evidence to suggest that it was the caregiver that harmed the child as opposed to somebody else?
I'm sorry, it has to be evidence, yes.
That it was-
either the caregiver or the caregiver failed to protect that child from the perpetrator.
And in order for a caregiver to fail to protect, wouldn't there have to be some evidence to suggest that the caretaker knew there was a problem or a potential problem?
That would be ideal. Sometimes you would have to assess the environment and assess and give it your best judgment, your best call in real time.
Okay. I am correct that in order for a caregiver to fail to protect, there would have to be some evidence to suggest the caretaker knew there was a problem or a potential problem.
Yes.
Okay. And where there's no evidence that the caretaker knew anything at all about a potential problem, then it wouldn't be appropriate to remove the child from that caretaker, would it?
Yes, it would. That may even be more concerning if there's evidence of physical abuse or injury to the child and the caretaker not even know how it occurred.
Okay. So it's Orange County Social Services position that if a caretaker does not know how an injury occurred, it's then up to the caretaker to prove their innocence.
And the state's testimony.
It's not a matter of innocence or guilt. Our primary job is to assess what's happening with that child and to protect the child. And it certainly isn't one to impugn the parent until we find out really what happened to the child.
So you won't impugn the parent, but you will take the child, even if there's no evidence that the parent injured the child.
If the child is injured and we have consulted with medical staff that says that these injuries occurred in a non-accidental way, yes, we will.
And just so I'm clear again, you won't impugn the parent, but you will take the child even if there is no evidence that the parent injured the child.
Yes.
Going back to one of your earlier answers, you had told me that it's been the consistent message for the most part, long before 2012, strike that.
Sean, I think you do better without that thing.
Yeah, well, I got this thing he said that I want to follow up on, and then I got off on a trail somewhere else, so I want to come back to this and get it pinned down, and I have to get it sorted out before I can do that. Okay, I think this is how we'll do it. I'm going to read back the question and the answer just so you have context.
Okay.
And then I'm going to ask you some questions about
Sure.
your answer.
Okay.
Okay. And my question was, so am I correct then that you did the training not because you were concerned necessarily about the rights of the people that were impacted by your agency, but instead because of concerns over litigation? Answer: we're always concerned about the rights of our families, and we feel as though we've always maintained that concern. What we wanted to do was formalize that training to to make sure that everyone was told, was given the same consistent message. Question. Okay, and that consistent message was what? Answer. That consistent message, for the most part, which has been the message long before 2012, is that is a practice that we put in place, that I actually put in place with regards to primarily what we wanted to look at is removal of the child only when it is to be or considered exigent circumstances or the language that makes my workers and staff use imminent danger. And what I want to ask about is when you said it has long been your agency's consistent message that you wanted, am I understanding correctly that you wanted your social workers to learn, understand, and recognize the constitutional rights that parents and children have to stay together?
That's correct.
Okay. And you understand that that constitutional right that parents and children have to live and stay together is guaranteed under both the 4th, 14th, and First Amendments to the United States Constitution.
Yes, I am.
You also understand that in the absence of a true emergency, it's improper to intervene in that family relationship that's preserved by the Constitution.
Yes.
Okay. And in fact, there's a well-established body of case law that you are familiar with in your capacity as the director of Orange County Social Services Agency that governs the conduct of your social workers.
Yes, I am.
Okay. And you're also familiar with the legal proposition that it's improper to remove a child under constitutional theories unless there is reasonable and articulable evidence to support the proposition that the child is in immediate danger of suffering severe bodily injury or death at the hands of the parents, correct?
Repeat that, please. Let me make sure I understand what your question is.
Sure.
Counsel, I'm not sure I heard your complete comment.
I'll let him read the question, then let him pose my objection.
Thank you.
You are familiar with the legal proposition that it is improper to remove a child under constitutional theories unless there is a reasonable and articulable evidence. Actually, let me reread that whole thing. I'm messing it up. You are aware that it is constitutionally improper to remove a child from the custody of its parents unless there is reasonable and articulable evidence to support the conclusion that the child is in immediate danger of suffering severe bodily injury or death in the time it would take to get a warrant if the child's left with the parents.
That's correct.
Okay.
If I may.
Well, hold on.
Well, hold on, if you want to
No.
make your answer complete. If he
The
wants to
answer
add
was
something to
correct,
it,
and I have follow-up, and if he wants to explain himself in the follow-up, we'll deal with that.
please continue.
No, absolutely not.
Okay, then you're not getting his complete answer,
That's fine.
and we'll,
You
can't
can,
you can't cut a witness off. You can't do it at trial, and you can't. Do it here, Sean.
you can move to do whatever it is you want to do.
I'll move to strike the question and the answer because you've not
That's-
allowed him to answer it.
That's fine, he's answered it.
And I move to strike it. You haven't. He hasn't. Provided
Motion's denied.
You haven't allowed him to provide his answer, so
Motion's denied.
The answer's worthless.
Motion's denied.
I'm sure Judge Stock will appreciate your humor.
You're also aware, aren't you, that where there is no evidence to support the proposition that one of the parents harmed the child, it's improper to remove the child from that person's care.
That's true.
Okay, so if you have one parent where there is a reasonable suspicion that parent harmed the child, but you have another parent where you have no evidence at all to suggest that parent harmed the child, in order to remove the child from the non-offending parent's custody, you need to go get a warrant, correct?
Unless we feel as though the non-offending parent failed to protect that child, knowing who the perpetrator is.
Okay. So you have to have some evidence to suggest that the non-offending parent knew who the perpetrator was, yet failed to protect the child.
Yes.
Okay. And when there is no such evidence, it would be improper to remove the child without first obtaining a warrant or court order.
Not necessarily.
Okay, give me all the circumstances where not necessarily applies.
It's overbroad.
I can give you one example.
Sure.
A married couple. It is safe to assume that since they are a married couple living together, it would be a safe guess to say that the non-offending parent would know who the perpetrator is.
When we're making the decision to remove a child, let's use your example from a married couple, doesn't the conduct of the agency to protect the child have to be narrowly tailored to avoid impinging too far on the parent-child relationship with the non-offending parent?
Yes.
And by narrowly tailored, doesn't that mean that we have to look for less intrusive alternative means than full-out removal from both parents?
That's true, and oftentimes we do.
But not always.
Not always.
Okay.
Depends on the circumstances.
Okay. And when you don't have any evidence to support a conclusion that either parent injured the child themselves or even knew about somebody injuring the child, what would the less intrusive alternative means be there?
It's compound, and it's vague and ambiguous and overbroad.
As far as I'm concerned, if there is a child that cannot speak for his or herself and there are significant injuries and the physician tells us so, we will detain that child until we find otherwise.
What happens when there's conflicting physician reports?
What we know we have is we have a child with injuries. Until there is further discussion or consultation with medical staff, we will err on the side of safety for that child.
And by error on the side of safety for the child, you mean you will remove that child from the care of its parents without a warrant or court order, even when there is no evidence to suggest those parents either harmed the child themselves or knew the child was harmed?
If it is exigent circumstances, yes.
What do you mean by that?
Again, as I had stated earlier, when there is immediate harm to that child, that if that child is left in that environment or in a situation where it could be brought back to that environment, we will detain that child.
How long did you spend preparing for your deposition?
A few days.
All day?
No.
Well,
No,
why don't
not
you give me
all
an
day.
hour estimate? How many hours?
Maybe 5 or 6 hours, something like that, throughout the past several days.
Have you been deposed in one of these civil rights cases before?
Many years ago, yes, I have.
What case was that?
That was a case, actually, it was an internal, it was a personnel issue. And I was deposed on the grounds that employee was released based on race.
How many years ago was that?
Would have to have been probably about maybe 13 years ago, maybe something like that.
Hey, Sean, it looks like you might be shifting gears. Do you mind if we take a bathroom break?
Just one more question. I'm not quite there yet, but I'm close. Well, you know what? You want to take a bathroom break? I
I'm
don't
good
really
for
need
right
one,
now.
but if you
I'm
need
good
it,
for right now, but
Well, then keep going. I can wait till you get to a logical breaking point. Then.
I don't want to torture you if
I'm
you're.
okay. I know you do.
No, I don't.
How about the reporter breaks the tie?
Do you need a break?
Sure.
All right, let's do it.
it works for me.
We're going off the record. The time is 11:07 a.m.
Okay, or did I just think okay? You just thought of it. Okay. All right,
So
sorry.
back on the record, the time is 11:25 a.m.
Okay. Mr. Riley, earlier in your testimony, you said it's long been your agency's consistent message that you want your social workers to learn, understand, and recognize the constitutional rights that parents and children have to stay together.
Yes.
What have you, acting as the head of the agency, done to ensure that your policies are followed?
It's a objection. It's overbroad. You can answer the question though, if you understand.
Okay. There's two ways. One, training. And since 1996, the California Social Work Educational Center, which is otherwise known as CalSWEC, provides standardized training for all
I'm sorry, was that CalSWIC?
CalSWEC. Cal, CalSWEC. California Social Worker Educational Center.
Got it. Thank you.
That's a collaboration of many of the UC and Cal State universities, depending on the region, that provide standardized training for all first-year frontline social workers. And laws, civil rights, and ethics is trained and has been trained since that time,
Since 1996?
since 1996.
You said there were two things. One was training,
The other part, of course, enforcement of that training.
and just share with us what you mean by enforcement.
It is incumbent upon our supervisors and our program managers to make sure that the social workers are discharging their duties as they're trained and as we expect them to.
And what does your agency do to make sure that actually happens?
In unit meetings, when they meet with them on a regular basis to make sure that they are, again, following policies and procedures and that they are doing what they need to do to keep families together or to keep children safe. That also includes from our quality assurance unit to randomly pull cases from time to time that has nothing to do with any particular issue, but just review cases to make sure it's going well. And also for the supervisor to call the families, at least one social worker every 6 months, to call and see how the social worker is treating them and how that they feel supported by the social worker.
Do you ever hear complaints, let me put it this way, since, say, January 2008, have you ever heard complaints from parents that social workers were being less than honest in their court reporting?
Yes, we've had those complaints.
Have them frequently.
It's vague.
We don't have them frequently, but we do have them every now and then, and we take them very seriously when we get them.
Are you aware of whether or not any social worker for your agency has testified in their deposition that in up to 50% of the cases, parents complain of social worker dishonesty in their reporting?
I wasn't aware of that, but I'm aware that we get several complaints that they're not happy with their social worker.
Okay. You attended, didn't you, the oral argument on the Fogarty matter?
No, I was not there.
You weren't there?
I did not even know that case was going on until after it was over.
Okay, and did you yourself undertake any investigation of that case after it was over?
We looked at that case. My understanding was we looked at that case as we do all cases brought before us with potential litigation to discern whether or not there's been any proprieties or any illegalities or anything that was done improperly. Afterwards, we also reviewed it just to make sure.
And it was your position after a jury entered its verdict against the social workers and Orange County that the social workers did nothing wrong.
That's correct.
Okay. I'm going to mark as Exhibit 134 to your deposition a memo. And I'm going to ask you if you would identify that memo for me. What is that?
Can you have an opportunity to read it?
Sure.
Okay.
What is that document that's been marked as Exhibit 134?
This is a document sent out by Ingrid Hirita, then the Director of Social Services Agency, in regards to the recent court actions taken in regards to the Fogarty Hardwood case.
Does your name also appear on the document right underneath Ingrid Harita's?
Yes, as Chief Deputy Director.
Okay. Did you partake in any drafting or reviewing of this document before it went out?
Reviewing, but not drafting.
Okay. Do you know who did draft it?
Ingrid Hirita.
Okay. And you reviewed it before she sent it out to your
Yes.
social workers?
Yes, I did.
Okay. And you agreed with everything in it?
Yes.
Okay. Did you yourself undertake any investigation of the Fogarty Hardwick allegations after the jury rendered its positive verdict?
By me, myself, meaning I personally did the investigation, or I had staff do the follow-up investigation.
Well, did you personally yourself do any investigation? Did you review any documents, talk to any social workers, anything?
Yes, I reviewed documents and talked to social workers.
Who did you talk to?
I talked to the two social workers, the one social worker and the supervisor that were directly involved, and talked to the quality assurance staff as well as program managers.
That would have been the social workers were Helen Dwojak, the supervisor, and Marcia
Marcia,
Vreeken.
right.
Correct.
Talked with both of them.
And what did they tell you?
They, for the most part, told me that they discharged their duties within regulation and appropriately.
And that they followed all the county's policies, practices, and procedures that were in force and effect at the time.
That's correct.
Okay. Were any policy changes made as a result of that verdict?
Not as a result of that, but we already had policy changes in the works as far as practice changes. That's when we went into our family-to-family model. That's when TDMs came into play.
And just so that I'm clear here, was it your position after speaking with Ms. Dwojak and Mrs. Vrieken that they did not lie and suppress exculpatory evidence? Was that your position?
That was my understanding, yes.
Okay, so even though the jury disagreed with you, that's still the position you took?
Yes.
Okay. What was the purpose of this letter that you sent out to your social workers?
As I'd stated earlier, we did not even know this particular trial was ongoing, and we didn't find out till after the fact. So the purpose of this was to, if you will, kind of serve as a heads up that these kinds of things can happen in the future, that before these kind of things occur again, they should consult with their managers, deputies, and go up the chain to make sure that they get adequate support.
Okay. We also told your staff here that the defendants were indemnified by the county.
Yes,
And by indemnified, that means that the county paid the judgment for them.
that's correct.
And you also told the staff that you sent this memo out to that the county also paid the punitive damages award against Ms. Dwojak and Mrs. Vrieken, correct?
That's correct.
And did the county actually do that, pay the punitive damages award?
Yes, they did.
Okay. And you understand, don't you, Mr. Riley, that punitive damages are a punishment that the jury assesses when they make a finding by clear and convincing evidence that the conduct of the defendant social workers was engaged in with malice, oppression, or fraud.
It calls for speculation and it calls for a legal conclusion.
I understand the question.
You understand that that is correct?
I understand what punitive damages are.
Okay, and you understand that in the Fogarty case, the jury actually returned a verdict saying that Ms. Dwojak and Ms. Vrieken violated Ms. Fogarty Hardwick's constitutional rights maliciously, oppressively, and fraudulently, correct?
That's what they said.
Okay, and you disagreed with that?
Absolutely.
Okay, and that's why you indemnified the social worker defendants?
Yes.
Well, it lacks foundation that this witness indemnified these.
Who made
social
the
workers.
decision to indemnify these social workers?
The Board of Supervisors.
Okay, and that was in consultation with you. You actually presented in a closed session before the Board of Supervisors, correct?
Well, hold on a second. No. That would invade attorney-client privileged information. If it was presented in a closed session meeting, you don't get to ask him questions about it.
Well,
Don't answer the question.
was it in a closed meeting or open meeting that you suggested that the board indemnify these social workers for punitive damages?
It lacks foundation.
I did neither. It was a recommendation that comes from risk management, not me.
Who at Risk Management made that decision,
Calls for speculation.
if you know?
Let me see. I was trying to think of who the director was at that time. The current director is Tom Phillips, but I don't think he was there then, but I'm not certain.
Okay. Did the risk manager director make that decision in consultation with you?
Yes.
And you agreed
And
with him?
Ingrid and Miss Harita.
Okay. And you agreed that they should be indemnified, the
Yes.
defendant social workers?
Yes.
Okay. I'm sorry, you agreed that the defendant social workers should be indemnified for the punitive damages assessed against them?
Yes.
And then in May of 2007, you reviewed and approved of this memorandum that was then sent out to staff, letting them know that you supported them and that you stood behind them, correct?
As long as they work within the scope of their responsibilities and duties, yes.
Okay. And in fact, you said this. It's the long-standing policy of the Social Services Agency, CEO Risk Management, the County Counsel's Office, and the Board of Supervisors to stand behind county employees who undertake their job performance in good faith on behalf of the county and the people we serve.
Yes.
So it was your position, and you were communicating this to your staff, that the conduct that Ms. Vrieken and Wojak had been found liable for by a jury of Orange County citizens was in fact in good faith and in the performance of their job duties as county employees.
Yes.
Okay. Did you review the verdict before you made this decision?
Yes, I did.
Did you review the transcripts of the trial before you made this decision?
Not the transcripts, no, I did not.
Okay, all you did was talk to the defendants, Mr. Wojak and Mrs. Vrieken?
And counsel.
Well, I'm not allowed to ask you about that. I'd love to. but- Now, one of the things that you do, and correct me if I'm wrong, but I'm assuming you do this, is when the appellate courts come out with important decisions, whether they're published or unpublished, that affect the work that your agency does, you review those decisions.
Yes, I do.
And to the extent that some sort of remedial policy decisions need to be made, you're the one that would make those decisions?
Yes.
And then you would either yourself promulgate a policy or direct one of your subordinate staff members to promulgate a policy for your approval that would then address the appellate issues.
Yes.
And when an appellate court specifically calls out your agency and says, in essence, to you, what you're doing needs to stop, do you take that seriously?
I take that very seriously.
Are you familiar with a case called Jonathan M.?
No, I'm not.
Okay. We're going to take about a 10-minute break, and I'll see if I can give you a copy.
Okay.
Now that you have seen almost 1.5 hours of the first segment of a 4-hour video deposition, let's go to our second video that shows how you, the lawyer, paralegal, or a judge hearing arguments on motions to exclude questions and answers that were objected to during the deposition.